People versus Cabrera, number 65.
Yes. I'd like to reserve 5 minutes for rebuttal, please.
5.
Yes. May it please the court, Barbara Zolot for appellant Ramon Cabrera. I'd like to begin by addressing the Miranda point. When Mr. Cabrera was handcuffed, he was placed in Miranda custody. Indeed, the fact that handcuffs put someone into custody seems almost too obvious a point to require extended discussion.
So are you arguing for a per se rule on handcuffing?
Yes, Your Honor, we are.
And is that preserved?
Yes, that is preserved. Below, defense counsel said that when someone is handcuffed with 3 officers around them, they are in custody, and then very significantly, the prosecution joined issue on the exact question of whether handcuffing puts someone into custody,
Would a
stating-
per se rule cover a situation where an officer handcuffed someone but specifically said, you're not under arrest, we just have to, I don't know, secure this thing or whatever? Would that be vitiated by a per se rule, or?
No, Your Honor, we would still say the per se rule is the correct rule because handcuffing is so overwhelmingly a severe restraint and coercive that even those sorts of factors, and I'll add that in United States against Newton, the Second Circuit considered situations like that and said no, when a person is handcuffed, the handcuffing is such a severe restraint that they're not going to believe they are free to leave simply because the officers might make some comment that, arguably vitiates it somewhat.
Well, you
So
have
do
to
you
leave
read
with the
Newton?
handcuffs on.
Excuse me?
You have to leave with the handcuffs on.
They'd have to leave with the handcuffs on. And the only thing a reasonable person could believe when they're handcuffed is that the police have no intention of letting them walk away. And I'll also add that this court has framed sort of an alternative test for custody in People Against Alls and People Against Bennett, following the Supreme Court's lead in cases like Quarles and Beeler, asking whether the restraint imposes, curtails the freedom of movement to the degree associated with a formal arrest. And we all know, and we cite multiple cases in our brief, that handcuffing is the signature hallmark and trapping of an arrest.
Counsel, do you read Newton or any other cases as imposing a per se rule as opposed to saying, it may be necessarily given significant weight, the formal, hallmark, et cetera?
Newton doesn't come out and declare a per se rule, that's true, but I think it comes as close as you could possibly come without declaring a per se rule. It all but did, because it did have these arguably countervailing factors there. I believe it was that the police told Mr. Newton that he was not under arrest. You could have these countervailing factors, and nonetheless, Newton looked at handcuffing and said that controls the analysis. So while Newton didn't declare a per se rule, I think it's very, very strong authority. I'd also add that this court's no stranger to per se rules. I'd like to point this court to People Against Shivers, where this court held in a non-arrest detention that holding someone at gunpoint puts them in Miranda custody. This court didn't look at any other factors. A gunpoint detention puts an individual into Miranda custody. And the same concerns that this court expressed in Shivers are very much present here. Very severe restraint where the suspect, and of course Fifth Amendment custody is viewed from the perspective of the suspect, would never believe they were free to leave with a gun pointed at them, or when they are handcuffed and physically unable to walk away, and that this is a very coercive restraint that's likely to overcome or runs the risk of overcoming a person's will to resist. So a per se rule is the appropriate rule here. It's the right rule for this state. It really benefits the state and the accused because it provides law enforcement with certainty about how to behave in the field. They will know that rather than engage in some freewheeling balancing test in the moment, if they choose, for safety reasons, which may well be reasonable under the Fourth Amendment, that's a separate inquiry, but if they choose for safety reasons to handcuff someone, then they, before engaging in interrogation, would need to administer Miranda warnings.
So
They would know
assuming,
that.
for the sake of argument, that you are correct in this particular circumstance, that he was in custody, the next question is what happens to his statements?
His statements are, because he was not Mirandized in this case, and no exception exists in this case to excuse the failure to Mirandize, the statements are suppressed in this case, as well as the guns that were recovered as a result of those statements.
Well, so let me ask you about the guns, sorry, because an ATF agent called and told the New York police that he had guns in the car, and that's why they interdicted him. You know, they knew where he was going and they stopped him. So is there an independent source?
Well, that was never argued below, and I believe if Your Honor is getting it like inevitable discovery, the guns would be the primary evidence, and inevitable discovery doesn't address primary evidence. But again, that was never argued by the prosecution
What
below.
about the written consent at the station house?
Well, that fails for at least two reasons.
If we were to think that that was voluntary, would that cure, and I understand your view is that it's not, but would that cure if he was in custody, would that cure with respect to the guns?
No, under the sort of Chappell analysis, because there's no real, break in the taint from the initial illegality in obtaining the statement and the consent that followed and the...
Well, what about the fact that it was an hour and a half later that he gave the consent, he was no longer cuffed, and he was specifically told he didn't have to speak to them?
Well, he was cuffed up until that point, of course. The cuffs were removed once he was at the precinct, but it was it was conducted by these same officers. You know, many of the factors that we look to for attenuation, there really are none that would allow for attenuation here. It was the same officers who were involved.
Counsel, at that point, had they already looked in the trunk? At the
They
point where
ha-
he gives consent at the station?
Well, they had looked in the trunk after he had given his consent, seen
And they
the
found a
stock of
gun
the rifle.
there, right?
But they went back and conducted the search only after he had given his written
My
consent.
point, I guess, is a little bit different. It's that at the time he gives the consent at the station, he knows they've already looked in there and seen a gun, right?
Well, that could equally say that he had no choice but to
No,
give
that's the point,
yeah,
I
he had
think,
no
yeah.
choice but to give the
cat's
cat out of
already-
the
yeah.
bag, essentially, yes, yes.
And with respect to what the police officer from the other state said, it wasn't ruled on by the court, correct? If we were to say that you're correct, and we
Right.
suppress the statement and the guns, do the people get an opportunity to go back and have the court address that which there was no ruling on?
I'm sorry, address which issue?
The issue with respect to whether there was probable cause, based upon the police telling them that he was coming to New York.
Well, the people below argued that, they limited themselves to arguing that there was reasonable suspicion to stop Mr. Cabrera. I believe they also did argue that there was actually probable cause.
Right, but did the court rule on that? That's
Court-
the point.
I see. The court found that there was reasonable suspicion, but it had the opportunity to rule on probable cause. So I can't see why the people would get a second bite at the apple here. These arguments were put to the hearing court.
But you agree the court didn't specifically rule on that which they asked, on at least one part of it, their
Yes,
argument.
I'm sorry to say I don't recall if the court specifically ruled on probable cause. I know that the court found that there was certainly reasonable suspicion. But I, again, do not believe everything having been put forward to the hearing court, that they get a second bite at the hearing court deciding an issue that was litigated. I don't think LaFontaine works in the reverse, so to speak, that because the court didn't address it for the people, now it can go back to the hearing court for review of that issue.
What's the remedy for this particular violation? Does he get his plea back now?
Well, because he was convicted of weapon possession, and the guns are what he was convicted of possessing, would be dismissal in this case. All the guns would be suppressed as a result of the Miranda and violation and the recovery of the guns as a
even if-
result.
If, for the sake of argument, there were a determination that the statement should be suppressed, but there was enough to find consent on the second part, would he still be able to at least withdraw his plea?
Yes, if,
Or
at a
should be
minimum,
permitted.
at a minimum, he's entitled to plea withdrawal under People Against Grant, plea vacatur under People Against Grant. But, you know, the consent itself is a fruit, you know, you understand our arguments on that front, everything goes. I see with the remaining minute, and then on rebuttal, I would turn to the Brune arguments that are specific to Mr. Cabrera. And in that regard, I want to first stress a very important point here, that Mr. Cabrera held a valid Florida concealed carry license. That's undisputed. And that fact largely dispenses with the state's argument that Mr. Cabrera has no valid constitutional complaint on the theory that he could have been denied on some basis other than proper cause, on the basis of some other theoretical lawful licensing provision in the licensing scheme that applied at the time. They don't actually identify which provision that would be. And so he would have suffered the same penalty of arrest, prosecution, conviction, and a 4.5-year sentence.
So New York, are you saying that New York was required to just accept that he had a Florida license?
What we're saying, that's not the argument, Your Honor. What we're saying is that because he had a valid Florida license, which is undisputed, he satisfied the objective requirements, the rigorous objective requirements of Florida's shall issue regime, which included that he had no felony or actually any criminal convictions, no history of mental illness, no history of alcohol or substance
Was there a
abuse
residency requirement? What, did he
for
have-
Florida's concealed
No,
carry.
for New York.
New York has a residency requirement for even applying for a license. It's
Right.
not within the general eligibility
Where in the
requirement.
statute do you see that?
That is in 400 sub 3, in that it only, and the district courts that have considered challenges to the residency requirement corroborate this, it only allows an extremely narrow exception for people who, where their principal place of employment is in New York. The record does not, the people certainly haven't argued that Mr. Cabrera's principal place of employment was in New York. In fact, he held a Florida driver's license, he gave a Florida address. He would have been, to the extent we've turned to sort of the residency issue, New York's licensing statute effectively disarmed him completely from even applying for a
And
license.
how did Bruin affect the structure in New York?
Well, that, now turning to the residency, that disqualification, that disarming of any non-resident, even those who hold valid licenses, who have complied with the constitutionally compliant schemes of their state, Bruin would demand that the people show a national historical tradition of completely banning non-residents from even applying for licenses. Mr. Cabrera had no lawful path to avoiding criminal prosecution for possessing a gun in New York because he was banned even from applying for a license. So
Well, I
Bruin
think he
would
could come to the state without a gun and then apply for a license, right?
he could arguably come, but that's forcing him to choose, which kind of pivots to our privileges and immunities argument, that's forcing him to choose between his fundamental right to travel to New York and other states and exercise his Second Amendment rights in New York subject to lawful regulation. Because New York completely disarmed non-residents from ever having that lawful path, he couldn't even make that choice.
The record is clear that he's a non-resident? That's not in dispute?
My adversary has disputed it. We believe the record provides adequate proof, ample proof to conclude that he was a resident. As I said, he held a valid New York license, a valid Florida driver's license, gave his address as a Florida address on the rap sheet that was used on the vouchers in this case. He said he was going to his mother's house. But a point I do want to make is that between the robust record we have that Mr. Cabrera would have satisfied the at least lawful remaining provisions that Brune didn't directly invalidate because he had satisfied Florida's objective provisions, which Brune approved of, between that robust record and the evidence we have that he was not a resident, at a minimum, this is the kind of case that should be remitted for further fact-finding, because if Mr. Cabrera could show that he could satisfy the other lawful provisions of New York's scheme, he should not be prosecuted for weapon possession.
Before you go, can you speak to your preservation argument with respect to this very compelling constitutional claim?
Well, in a way, I'll just be repeating what others have said. I could, but there is a futility exception. And with respect to some of the points that were made, as far as Patterson goes, there was this claim, oh, that was just about mode of proceedings. That's what that case was about. Well, the reason why Patterson spent so much time on mode of proceedings was because that was like a brand-new concept that the court was introducing. When it was talking about futility, it was just restating a rule it had previously held in Baker with respect to Bruton, which was not a mode of proceedings era, and it also relied on O'Connor v. Ohio, which Baker also favorably cited, which is very significant. That's a Supreme Court case where the Supreme Court, in fact, it gets kind of involved, but there was a Griffith v. Ohio, which talked about comments on a defendant's right to silence.
But it seems like a futility argument it's a complicated one here, because there's the futility of arguing a specific issue we've decided. So if you were going to argue the misdemeanor enhancing the home possession, we did that, we applied the old standard, and we said no. As far as I know, we've never decided the constitutionality of the residency requirement under the old standard. So we have to take it a step further and say it would have been futile to make that argument because the old standard you would have lost. That's different to me than saying it's futile because this court has decided something.
It's a more subtle argument, but at the same time, we know that under the law that had addressed the residency requirement, Bach v. Pataki, for example, in the Second Circuit, it was all decided under means-end scrutiny. It was the same thing. Means-end scrutiny was like the go-to for deciding any objection to New York's licensing scheme.
But we would have had some record if that had been done. We would have perhaps even had the residency record, right?
Arguably, yes, but I think that, given how Brune upended the mode
But it's
for...
not the upending I think you're relying on, it's that it wouldn't have made any difference. It's a futility argument, right? Brune upended a lot of things, but it's the futility argument that gets you by preservation. And I just think it's a very different argument on futility to say we've already decided the issue than to say, well, the test is different now. Because let's say they did this in another context and there used to be rational basis, now it's intermediate scrutiny. Anyone can come in and say, if you fall within the new test, well, we didn't have to preserve a challenge to this because it was an old test and we would have lost.
Well, even if we agreed with Your Honor that this is somehow different, remember that Mr. Cabrera was still injured by the proper cause requirement, and, so that's very much
Again, that
subject
was
to the
never
futility.
litigated here either, right?
Well, in any of these cases, it wasn't litigated, but that's where the appellate division binding law, is very relevant because it would have barred any
But is it
challenge.
futility because of an appellate division decision, or is it futility because of us or the Supreme Court?
I think it operates at both levels.
But
It's fu-
litigants do make arguments to the appellate division, hoping to have this court or even the Supreme Court take them on and reach a different conclusion.
Well, but playing that out, there would have been no point in making the argument in the trial court because of the binding appellate division law. So any argument made in the appellate division, even if the appellate lawyer had wanted to be creative, would then be entirely unpreserved. So it's not going to reach the Court of Appeals anyway. It's sort of, in itself, an exercise in futility. It's going to end in the appellate division. And again, there would have been it would have been futile to address it in the trial court because of the binding appellate division law.
Can't argue for a change in the law in the trial court?
Well, the trial court has no power to really
But
overrule.
again, it's different here because it's not the issue that's been decided. It's the standard that's been changed. So you could make some record for us by objecting under the old standard, which hasn't been decided. We have never applied that standard to this issue. Let's use the residency requirement. So if you make an objection under the old standard, you develop a record in terms of residency, yes resident, not resident, it comes up, the standard changes, well, you've preserved it, and we have some indication in the record, but now it's just, well, I would have lost because it's a new standard, you never decided. That's a different futility argument.
Well, 2 points there. First, I mean, the validity of the proper cause standard, at least, had been directly decided by the appellate division. It had been validated by the appellate division.
But that finality exception is very narrow. I mean, this futility exception. So do we have a case where we've said you don't need to preserve on futility grounds where the appellate division has decided?
I'm not aware of that case, but as to the standard question, I think it's still futile because of this court's decision. We keep coming back to Hughes, but Hughes was decided after Heller and applied means and scrutiny.
Couldn't you have argued that, and you made some points yourself about the impact, in your view, that this requirement would have on your client who did have a license elsewhere? Couldn't you have argued that specifically were we to read the statute, and I think there are perhaps contrary arguments that your adversary makes, to not allow a license except in these narrow circumstances to non-residents, that didn't even pass means ends test that was set forth in Hughes?
I still don't see the point of making a means end argument when, even on other grounds, where New York State has been so overwhelmingly clear that these arguments are not going to succeed, applying means end scrutiny. So I think there's, the futility of Hughes having adhered to the means end rubric. There's the futility of making arguments that a trial court is bound to reject because of controlling precedent. And then there's the futility of, there's actually also the point of, should we be incentivizing trial lawyers to be making arguments that are bound to fail just so that they are technically preserved without making a useful record for a higher court?
On their point, it's well taken, I think, the point that if there's appellate division binding law that to request a trial judge to consider an argument that clearly has been rejected by the appellate division does seem futile. But then it does seem under the preservation rule that your first opportunity is at the appellate division. And then the question remains, why not then present it at the appellate division?
Well,
The request is to allow the court that can, of course, change its rule, overturn its rule, is the one that's hearing the argument.
Well, I could
This
give
is,
Your
I think,
Honor,
what Judge Garcia was saying, well, if we haven't decided it, what would be the obstacle, at least preservation-wise? Don't
mean,
you
I-
have to preserve it? What would be the obstacle to present the argument because we haven't decided it?
I can give Your Honor a sort of concrete example of what's flowed since Brune to give you sort of more like sort of a realistic sense of how these things might play out, which is post-Brune, in cases where the arguments were not made in the trial court. Appellate lawyers have been raising Brune, Brune arguments in the appellate division, and at least in the First Department. The way these have gone is this is unpreserved at the trial level, and we otherwise find it without merit. There is not any kind of, exploration of the arguments or vetting of the arguments that were made to the appellate division. So, I don't want to, keep using the word futility, but there's an aspect of futility there. The argument is unpreserved, and therefore, we can't get it to the Court of Appeals. And the appellate division is reluctant and, busy docket of its own to start doing this broad investigation of these arguments in an unpreserved case. So that isn't really a path
Well,
to vetting these arguments.
It is just a delay because, say you're right, it is just a delay at some point, which I think was the point one counsel for the Attorney General, there've been several, who tried to make, which is there will be cases where it is preserved, and those are the appropriate cases in which to consider the issues.
Well, they may be preserved cases, but if my client's conviction is a wrongful conviction because of Bruin's invalidation of proper cause and how my client was injured from that, and if, as we've argued, there is a futility exception based on intervening Supreme Court law, it would be an injustice not to give him at least an opportunity to fully establish that his conviction was wrongfully obtained by allowing him to develop the record that really there was no reason in the world, realistically speaking, for the parties to develop below before Bruin.
Counsel,
Have
can
any
I
of
go
these
back to?
arguments been made, I'm sorry, pursuant to 44010? Are you aware of any of those arguments being made? And could you have made that pursuant to 440?
Based on applicable First Department law, which is where we practice, there is case law that would bar us from bringing the 440 in part for the absence of preservation. This came up after Carpenter was decided. We attempted to bring 44010s based on this sort of change in the law, and there was a procedural bar based on the absence of preservation. We would love to bring 44010s in these cases, but at least as of now, there is a First Department case that prevented us from pursuing that path.
And someone could appeal that.
Someone
If we have
attempted
not,
to
if
appeal
we
it.
have not ruled on that, whether or not that preservation determination is correct.
As it stands now, that is the binding law in the First Department, yes.
I just want to go back to the residency requirement for one second,
Yes.
because I did take a look at 403, which has language that says an application shall be made, as the case may be, where the applicant resides, is principally employed, or has his or her principal place of business as a merchant or storekeeper, and in the case of a license as a gunsmith or dealer in firearms, to the licensing officer where such place of business is located. So it certainly restricts the bringing of license applications to certain classes of people. It sounds like in the place where they live or in the place where they have a business. But it doesn't specifically say that if you don't fall under any of these conditions that you can't apply for a license, which sent me back to section 400, which are the general eligibility requirements for who can get a license. And there's nothing there about being within the state or a particular county. So I'm not sure exactly what the basis is of your argument that 403 restricts residency in the way you
Right.
said.
Well, courts have interpreted the licensing scheme in response to challenges made in the civil context to these licensing, to the residency restriction, where people have been denied licenses or want to get licenses, and they're denied because they are non-residents. And one case in particular, I know my adversary cited the Osterweil case for the which actually held that part-time resident property owners can apply for a license even if they're not domiciled in New York. But there was a district court case before this court decided Osterweil, which discussed the licensing requirements in the context of residency, and said very plainly that subject to very narrow, not as just a matter of venue where you apply, but subject to very limited restrictions, exceptions, meaning it's your principal place of employment, non-residents have no access to applying for a New York license. That's how the courts have interpreted the licensing scheme. And the fact that in the prior argument, the Attorney General is almost tacitly admitting that, well, we need to construe it consistent with the Constitution, that may well be fine going forward, but that doesn't answer how the licensing scheme was interpreted when Mr. Cabrera would have needed to apply
He
for a
didn't
license.
attempt to get a license, right? I mean, we don't know how it would have been interpreted in your client's case because he didn't seek to get one and present that question, if I'm understanding the record.
Well, it would have been futile for him to attempt to get a license because, And in fact, Bach v. Pataki, where one of these challenges to the residency restrictions was made, Bach v. Pataki said you don't have to first try and apply because it would be futile. It would be a totally futile gesture.
Yeah, but it seems to me that to the extent the Attorney General is arguing for a different reading and one that does not impose a residency requirement, couldn't your client have tested that by actually applying? I'm not asking specifically with regard to preservation, but we don't know the answer to the question in part because there was no effort made to get a license here, right?
That's true. There was no effort to get a license, but again, it feels sort of circular because if Bach v. Pataki if it's absolutely futile to attempt, then why would someone be motivated to attempt to get one, only to lodge a challenge to it when it's been held to be a valid restriction already? I mean, we come back to futility again. And again, my client, having suffered a criminal conviction, is under no obligation to first apply for a license, coming back to the idea of standing, where he can raise his constitutional challenges as a defense to the criminal prosecution.
Thank you, counsel.
Good afternoon, Your Honors. May it please the Court, my name is ADA Joshua Weiss, on behalf of the Bronx District Attorney's Office, appearing for respondent. The suppression claims rejected by the courts below all presented mixed questions of law and fact that this court does not have the jurisdiction to consider. This is because the record below supports the lower court's finding that defendant was not in custody for Miranda purposes when police stopped him outside his mother's residence and briefly questioned him about whether he was armed.
Well, counsel, were we to adopt a rule that handcuffing automatically is custody, I don't see what the mixed question would be.
Your Honor, well, preliminarily, the request for a per se rule is entirely unpreserved. In the submissions before the suppression court, defendant based his arguments on acceptance of the existing legal framework that a determination of custody requires consideration of all the relevant circumstances. But beyond that, a per se rule would unduly hamper the ability of law enforcement to exercise discretion to take appropriate safety measures when encountering dangerous situations.
Why is that? Why is that?
I'm sorry, Your Honor?
Why is that? I mean, if an officer is faced with a dangerous situation that would, in that person's officer's judgment, would require handcuffing, the officer could handcuff the person and just either Mirandize the person or not ask any questions.
Understood, Your Honor, but certain situations don't lend themselves well to that sort of methodical process of arresting and advising. Oftentimes, police officers are confronted by volatile and fast-paced.
You didn't argue public safety here, right? You didn't argue a public safety exception, right?
No, Judge Garcia, we didn't argue public safety here. It's our position that public safety would require the existence of probable cause. And here, I submit that the police didn't have probable cause when they encountered defendant outside.
But even here, if you look at the facts, without the bright-line rule, a reasonable person under these circumstances, you're saying this defendant cuffed, and the circumstances surrounding that cuffing, he would think that he was free to just walk away?
Absolutely not, Your Honor. However, the standard for assessing a defendant's custodial status is far more nuanced than that. It requires not only looking at whether, it requires assessing not only whether the person is free to leave, but courts also have to evaluate the surrounding circumstances that surround the interrogation. And this rule, as I've just articulated, is a direct application of Miranda. As the Supreme Court said in Howes v. Fields back in 2012, not all restraints on the freedom of movement amount to custody for Miranda purposes.
But here, he was surrounded by officers at night. He was cuffed. How is that not custody?
Well,
Considering all the circumstances.
Considering all the circumstances, Your Honor, well, it's first of all, it's unclear when the defendant was handcuffed, but even assuming he was handcuffed when the question was asked, the record still provides support for the court's determination. The fact that the questioning was initiated by the police in a non-confrontational manner, the setting was outside the defendant's mother's home, none of the guns were drawn. Defendant was forthcoming in providing assistance to the officers by granting them permission to reach inside his car and retrieve his wallet.
What are, let's say we agree that it's not custody. What does that mean with respect to what he can do? Can he walk away?
No, he couldn't walk away, Your Honor, because he was seized under the Fourth Amendment. But the distinction drawn by Judge Marcus and by the appellate division below is that despite the seizure for Fourth Amendment purposes, he was not in custody for Fifth Amendment purposes. And the court's determination here is well supported by the factors I just listed. And moreover, the Supreme Court has held that a motorist who's detained during a roadside detention isn't necessarily in custody for Miranda purposes, even though that person experiences a significant curtailment on their freedom of movement and wouldn't be free to go. Of course, the defendant in Berkmer was not handcuffed as Mr. Cabrera was, but this court nor the Supreme Court has ever held that any one circumstance is dispositive, and there would be no reason to depart from that precedent today.
Could I
Did I
back
hear
up?
you?
I'm sorry, go ahead. Go ahead.
Thank you. Did I hear you to say that you concede that there was no probable cause?
Your Honor, the court found that there was reasonable suspicion. I do not believe, just trying to recall off the top of my head, whether we argued in our post-hearing submission that there was probable cause for arrest upon encountering the defendant. But it's always been our position throughout the litigation that only reasonable suspicion existed at the initial detention.
I was going to ask the exact same thing that Judge Halligan did. I thought earlier you said they didn't have probable cause when they stopped him. Is that right?
Correct. They did not have probable cause when they stopped him.
And so that then, I think, goes to the question Judge Troutman was asking earlier, which is there a reason to remit this to allow for a determination of whether there was probable cause? But if your view is there wasn't probable cause, I think that's the end of that. Does that make sense?
I think that does make sense, Your Honor. There are two circumstances where we would view remittal as appropriate here. If the court were to find that the timing of the handcuffing, if the timing of when the handcuffs were applied is dispositive to whether the defendant is in custody, then under this court's decision in Torado, it could remit if it believes that issue is dispositive. Alternatively, if the court concludes that the defendant is in custody, it could remit for consideration of whether the subsequent search given at the precinct once he was Mirandized and had signed the consent to search form sufficiently attenuated any purported prior Miranda violation.
What would be an example of, other than this case, obviously, what would be an example of handcuffing in which the person is not restrained?
A person, there is no example. Handcuffing imposes a significant restraint.
Always restrained, okay.
Oh,
So then,
Always restrain, Your Honor. But and more often than not, it will be a very significant factor in the analysis of whether a suspect is in custody. But the problem with the bright line rule is that it would erode the leeway courts have to make distinction, to engage in nuanced analysis, as Judge Marcus did here.
But why do that? Isn't counsel correct? It's a very clear rule. That's the beauty of the per se rule. The officers know. You handcuff, give them Miranda warnings, or don't ask any questions, or if you're going to ask questions, know that you're not going to be able to rely for prosecution purposes on whatever statements are made.
Because oftentimes when the police are in the field investigating crime, they have to make split-second decisions
And
that don't always, and the manner in which circumstances unfold don't always provide the opportunity for Miranda warnings to be
they
given.
have to make a split-second decision on occasion that they're going to arrest, and they know they've got to give those warnings once they do that. How is this that much different?
Well, yes, Your Honor, but it was not a foregone conclusion that the police were going to arrest Mr. Cabrera. The information they received.
No, I understand that. I'm just saying, to the extent you're arguing, it's not a workable rule. This is the way I heard your response to me. It's not a workable rule, given the dynamics and the dangers in the field. And I was just saying, but that is the rule when it comes to an arrest, and I can't really find such an easy distinction between the two.
I understand, Your Honor. Well, I would just...
What's your distinction between the two? That's what I'm asking.
I'm sorry, the distinction between...
Yes, the arrest also poses the same kind of situation you're arguing, right? The sort of the very fast dynamic, they've got to make split-second decisions, and yet the rule applies with respect to an arrest.
The...
Miranda ruling.
Yes, and that is true, that an arrest is not required. It's not always required that the defendant be formally under arrest for the Miranda requirement to be triggered. But the inquiry turns on consideration of all the relevant circumstances, and whether a defendant's freedom is restrained is only one step. The courts must also look to whether the questioning subjected the defendant to the sort of inherently coercive pressures that were at issue in Miranda. And this is directly from the Supreme Court's decision in House from 2012. I would also just direct this court to its prior decision in Chestnut from 1980.
Let me try this. What would make it not a coercive situation? Being handcuffed. Give me an example of when it's not a coercive situation. Being handcuffed is not coercive. Does not put coercive pressure on the person handcuffed.
Perhaps it would feel less coercive if the officer applying handcuffs tells the defendant that he's not under arrest, that it's just being done for safety precautions. But here, the use of handcuffs was one of many factors that was considered by the court below. And certainly, reasonable minds can differ about the inferences to be drawn. But because there is a basis in the record to support the findings below, we submit that this court cannot engage in any further review of the claim. Unless this court has any other questions about the Miranda issue, I'm happy to address the Second Amendment claim briefly. This court should reject defendant's Second Amendment challenge as both unpreserved and for lack of standing. Although the defendant, this was a case where it was truly unclear whether the defendant would have been able to satisfy any of the valid licensing restrictions that remain valid following Brune. And so the need to have applied was all the more essential so that the parties could have litigated whether there were other disqualifying factors. With regard to the residency requirement, the record casts aspersions on defendant's claim that he is a non-resident of New York. At the very least, it does suggest that he is a Florida resident in view of statements he told CJ after his arrest and probation before sentence that he intended to return home to live with his mother at the address where he was arrested. And in any event, even if defendant were a non-resident, this court has held that there is no domicile requirement for defendant to obtain a license. So in view of those circumstances, defendant still would have been able to apply. And on the merits, I do just want to make one thing clear about the Brune decision. Defendant's prosecution here, and in fact, I think all the defendants who are prosecuted here, those charges aren't predicated on the fact that they may or may not have been able to satisfy proper cause. It owes to the fact that they failed to obtain any license whatsoever. And that's precisely what happened in this case. Defendant didn't obtain a license, and he never claimed that he participated in conduct that would have accepted him from prosecution.
Thank you, counsel.
So, thank you, Your Honor.
Hello again, Esther Murdukeva for the Attorney General. I have 3 points I'd like to make on standing and then 2 points on the merits if I have time to get there. On standing, I think that term is a bit of a misnomer that comes from the way it's been used in the cases. Really, the question of standing is more about what legal issues are germane to the legality of the criminal prosecution. So if I'm prosecuted for unlawful possession of a weapon, I can't raise a constitutional challenge to a town zoning code, because even if I'm right, it doesn't matter. It has no bearing on my criminal conviction or the criminal charge. And the same applies here. What Mr. Cabrera is arguing is that he has constitutional challenges to the proper cause requirement and this purported residency requirement. But those are only germane if he would otherwise meet the licensing criteria. We do not know because he's never applied for a license. This record actually reflects he might not have been able to meet that criteria for at least 2 reasons. First, he admitted that he was selling weapons without a valid federal firearms license. Depending on how those transactions occurred, that could be a violation of federal law. And we know that he violated New York state law by bringing an AR-15 into the state, which is a banned assault weapon, as well as at least 3 large capacity magazines, which are also banned under New York law. So on this record, we simply have no way of knowing whether his constitutional challenges actually have any bearing to the legality of his conviction. The other 2 points I'd like to make about standing are why it matters. The first is that there is a fundamental rule of law concern here that is different from some of the First Amendment cases. The self-help approach in the firearms context of just obtaining a weapon because you disagree with the licensing scheme and not applying for a licensing scheme has deadly consequences in ways that do not manifest in the First Amendment context. And there are no cases in the First Amendment context that discuss the implications of the state's public safety interest on that kind of resolution.
That sounds like a good means-end argument.
Well, Your Honor, I'm not talking about the merits of the Second Amendment claim. I'm talking about the cases in which a Second Amendment claim can be litigated. And there certainly are cases where a person who believes that a state licensing scheme is unconstitutional will challenge that scheme, bring it up to whichever court is going to adjudicate it, which will apply the historical standard. I think what I'm arguing here is this is not the right defendant to raise this argument because we have no way of knowing the way in which the licensing scheme would have applied to him. And it would greatly disturb the purposes of licensing for firearms possession to simply allow a person to disregard the firearms licensing scheme, wait until they're criminally prosecuted, and then raise the challenge. There are real meaningful public safety consequences for that approach that just do not manifest in the Supreme Court cases that Mr. Cabrera cites.
Yes, I take this argument to be it would be a disincentive to apply for a license.
Correct, Your Honor, and a disincentive that can have deadly consequences. People haven't died from leafletting without a permit, which is one of the cases that Mr. Cabrera cites as excusing the need to apply for a license before raising a challenge.
Given Bruin's exclusion of means ends, how is that consideration relevant? And also, maybe distinctly, what do you do about the fact that the defendant was in fact convicted under a statute he claims is unconstitutional? I'm not sure why that's not sufficient injury in fact to confer standing.
So I'll take that in a couple of turns. Bruin did not say anything about whether unlicensed carry is constitutionally protected. It in fact went out of its way to say that licensing is constitutionally permissible. Therefore, I don't think it's accurate to characterize what Mr. Cabrera did as constitutionally protected because of Bruin. He may have some arguments about the way in which Bruin affects the legality of the statute under which he was convicted, but those arguments are all predicated on the constitutionality of a licensing scheme that has never actually been applied to him.
Why isn't your response to Judge Halligan a merits-based response as opposed to going to the question of standing?
I think the issues are related. The standing inquiry is really a way to channel this court's and other courts' judicial review of challenges to licensing schemes to cases where there is a record to meaningfully adjudicate that challenge. That was my last point about standing, is that the reason...
Well, I thought the argument is, look, Bruin said he's got a particular constitutional right. The licensing scheme affects that right in a way that is unconstitutional, as Bruin recognized it. That's the argument, and therefore the conviction has to fall. It's unconstitutional. People can argue anything in response, saying that's not what Bruin held. All of those arguments that are in the briefs aren't those merits arguments. But the standing is whether or not you can make the argument, yeah?
That's true, Your Honor, and the standing is about what kind of argument you can make. And if what Mr. Cabrera was arguing is that licensing is impermissible altogether, you just can't regulate this conduct through licensing,
Yes.
maybe that's a kind of defense that you could raise in a criminal proceeding. But here, what he's conceded is that there are some licensing criteria that can be constitutionally applied, and had he applied for a license, he would have been able to satisfy that criteria. That's a very different type of constitutional challenge.
But then I worry when you tell us to wait for some of the other 900 cases in which the argument was preserved. You see where I'm going, I can see by
I
the
do see where you're
smile.
going, Your Honor.
That we can't do anything with those because of your other argument, that the only way we can really get to this is by a facial challenge.
I understand that concern, Your Honor, and I guess my only answer, my best answer, is that preservation and standing are two separate inquiries. And the preservation inquiry is really...
I get that, but really then we should just disregard the fact that you've got a whole bunch of criminal cases. In some of them, the issue's preserved because you're going to come here and tell us that there's no standing and we really have to wait for another case. So all it means is that we should just, as persuasive as it was, it doesn't have any practical effect for us.
Well, it does from the perspective of preservation, right? Because there will be preserved challenges.
But we still
Whether
can't get to it.
whether a preserved challenge ultimately succeeds on the merits really is not part of the preservation inquiry, as you know. I think the other point that I will make is there is a lot of civil litigation that is challenging various aspects of New York's licensing scheme. And as those cases start to become decided, they will inform the way in which different criminal cases are decided, the way in which prosecutors are charging cases, and the way in which maybe this court ultimately considers a constitutional challenge in a properly presented case.
To that point, if I can, at least some of the defendants are requesting that their cases be remitted so that there can be some development of arguments on the Second Amendment front. So in light of your concern that you voiced about the need to build a record on the historical tradition, why not remit these cases specifically?
Well, Your Honor, in all of these cases, there would be a need not only to build a record on the historical tradition, but on these particular individuals' qualifications under the licensing scheme otherwise. So that would involve creating a record that's relevant to good moral character, creating a record that is relevant to other disqualifiers. You really would turn that remittal into a mini administrative proceeding involving counterfactual scenarios about an application that was never filed. That's just not an efficient use of judicial resources. If I may make just one argument about the merits and the consequences of the merits argument, and this really relates to both the challenge to the CPW conviction and the privileges and immunities claim. If Mr. Cabrera and the other defendants are correct, then every conviction for unlawful weapons possession in New York prior to the CCIA taking effect in September 2022 was unconstitutional. And if the same would be the result in the 6 other jurisdictions that had proper cause requirements prior to Bruin.
Well, could there be a difference between cases that have wound their way through direct appeal and are final and cases that were pending on appeal?
Possibly, Your Honor. That's typically a difference that comes up in retroactivity considerations. Even that would be a tremendous number. And given the severity of that consequence, both for New York as well as for the 6 other jurisdictions, which include California, Hawaii, Maryland, Massachusetts, New Jersey, and DC, you would expect the Supreme Court to have said something about that. If the Supreme Court really believed or intended for a consequence of Bruin to be an invalidation of existing unlicensed gun possession convictions, that is the type of consequence that you would expect to be addressed, and that is completely discordant with the statements made in Justice Kavanaugh's concurrence or Justice Alito's concurrence about the limited effect of the ruling.
So one more thing for you, and I won't hold you to this at all. This is just out of my curiosity. So this is just because you may have thought about this, and I'm not sure what the answer ought to be anyway. What would I assume that there, I know, I guess, that there are many cases in which indictment contains several charges, one of which or more might be criminal possession of a weapon, but other might be robbery or assault or something like that. And in some of those, a plea is taken just on the CPW, and the others by plea are dismissed. What would happen to a plea agreement in that circumstance were we to vacate the CPW on a constitutional ground? Do you get a chance to re-prosecute on the other ones, or are those waived, or who knows what would happen?
I have no idea. It really does highlight some of the preservation problems. So for example, if a constitutional challenge to the CPW claim had been raised, the prosecution might have charged differently. It might have offered a different plea agreement. In Mr. Cabrera's case, for example, the prosecution might have charged his SAFE Act violations with bringing the AR-15 and the large capacity magazines into the state. It's too burdensome and honestly difficult to unwind these counterfactual scenarios, which is one of the many purposes of the preservation requirement.
Thank you.
Thank you.
Just a minute on Miranda, then I'd like to address some of the AG's arguments. On Miranda, I think my adversary's argument that there should be some kind of broad totality test here, even where there's handcuffing, it just points, Mr. Cabrera's case points out the problem with that. I mean, the hearing court found that Mr. Cabrera was not in custody, arguably because, the tone of voice wasn't really commanding or whatever the other factors are, but there was handcuffing. I mean, that in itself.
I think we were trying to get at before what would be some circumstances where it might not be, right? So what if there's a stop, the officers think there might be some dangerous thing in the car, and they say, okay, if you want to stay here, I'm going to handcuff you. You're not under arrest, but for your safety and my safety, I'm going to handcuff you. Or you can go 40 feet over there and stand by that tree, and the guy says, no, I want to see what you're doing here, and they handcuff him. Per se rule?
Well, yes, there's still a per se rule because we can imagine scenarios like that. But they are such outliers and so unlikely to occur.
There's People v. Green out of the 4th Department, which is there's an officer with a defendant, puts him in handcuffs because he's providing evasive answers and standing close to several sharp farm implements. And the officer informs him he's just trying to sort out what happened during the accident, and the defendant isn't under arrest. But that's a real scenario. But we wouldn't get into any of those factors because once he handcuffs him, it's a bright line rule.
Well, two answers to that. First, that itself is really a very unusual fact pattern, and it doesn't make sense to create a rule, a mushy, look at everything rule around what's really a very unlikely scenario when the per se rule would reach the correct result in the vast majority of cases. I mean, the juice isn't worth the squeeze to have a rule that's taking into account all these. But aside from that, what Your Honor just described, the analysis would be if the person's put in handcuffs, there's custody. And then the hearing court would say, okay, that person is in custody, were Mirandas administered? And if Mirandas were not administered, then the question would be, is there an exception to giving Miranda warnings? And there are two limited exceptions, one of which might well have applied in Green. There's the public safety exception, which my adversary says wasn't argued here.
Public safety, as I understood it, was always more, is there a bomb in the trunk? That's the question you can ask without Miranda, right? I don't see this, because you might get access here, I'm handcuffing you, is a
Right.
different public safety argument, right?
Well, the other exception is sort of more relevant, which is the so-called Huffman exception, which really goes to whether or not it's interrogation or not. And the Huffman exception says that when the police happen upon something volatile, confusing, they're trying to sort it out. In Huffman, there was someone behind a bush and it was late at night and no one knew what was going on, that when there's that sort of volatile, confusing situation, then it's not about custody. The individual is in custody. They were in custody in Huffman, but whether there's an exception that excuses the absence of Miranda warnings, and, that sort of situation would. So, it really doesn't need to be, the court could find custody and then still accommodate what might be sort of unusual situations that would still give the police ample leeway to do their investigation. On the Brune point, a couple of points there. I mean, first of all, this idea that because my client May allegedly had an AM-15, an assault-type weapon, he was convicted of possessing a single pistol, and he is challenging his conviction he's challenging that conviction. So these other facts, which remain unproven, and he didn't plead guilty to them, are really not relevant to the analysis. In terms of the Attorney General's...
Could he be re-indicted on some of the other charges?
Well, I believe if his plea were vacated, those counts would be revived. And to Your Honor's point also about the other charges that are joined, that has relevance in other ways too. I mean, oftentimes CPW convictions are joined with more serious charges. So this idea that undoing the criminal weapon conviction would, unleash all of this on New York State. I mean, first of all, a number of these clients who pleaded guilty may well choose not to take that risk because it would revive those other charges. But in addition, there are other charges that the individual may well remain convicted of if they were also convicted of those charges after trial. And there is precedent. This Brune is really like not just once in a generation, but probably a once in a lifetime type of case. It's reimagining the scope of a constitutional right. And it would lead to work by the lower courts in figuring out what to do with these possibly unconstitutional convictions. But there's precedent for this court taking that action in the PRS context. This court reached a decision on post-release supervision that led to resentencings in untold countless number of cases, but it was called for by what this court held in the area of post-release supervision and the need for courts to actually pronounce it. Where potentially unconstitutional convictions are at stake, it seems as though the imperatives are even greater to make sure that people aren't serving substantial time in New York for unconstitutional convictions that are traceable to the proper cause requirement, as is the case, or may well be the case in Mr. Cabrera's case. So for those reasons, we ask the court to, at a minimum, remit on the Brune issues.
Thank you.